Welcome to Law Subscribed. This is your dedicated news source for all things subscriptions in the law. My name is Matthew Kurbis. I'm the subscription attorney, and I believe subscriptions can help bridge the access to justice gap and incentivize attorneys to modernize and scale their practice like never before. On this show, I interview lawyers ditching the billable hour and experts who can help attorneys move beyond billing time. Thanks to my sponsors, 650 and Gavel. Links to both in the show notes. More on them later, and use the code LAWSUBSCRIBED when signing up. You get 10% off, and it supports the show. The best way to support the show is to share it with someone you know. This podcast is for educational and entertainment purposes only, and nothing said is legal, ethical, or financial advice. Without further delay, here's the episode. I'm thrilled to have with me today what is either like my second or third litigator using the subscription model on the show, Jody Winter. Welcome to the podcast.
Well, thank you. I appreciate being here.
So I've been able to peruse your website, but for my listeners who haven't come across you yet, go ahead and give yourself a little introduction.
Sure. Well, I'm the founder and CEO at Lloyd Winter PC, and our mission at Lloyd Winter PC is to provide access to justice. And for us, that's twofold, both man's justice and God's justice. And so we provide access to man's justice through flat monthly billing on our civil litigation matters, and that's in both California and now in Texas as well.
So you say flat monthly billing. Is that language that you use for consumer facing, or why isn't subscription part of that explanation, that elevator pitch?
Yeah, that's a good question. So we don't have permanent litigations, right? So litigations have a timeline. Mm-hmm. And we have found that flat monthly billing is a really good way to alleviate some of the problems. But I think it's important for us to kind of define the terms a little bit on what access to justice really is. And for us, access means opportunity, not outcome, right? So we want more equal opportunity, not equal outcomes in civil litigation. So it's really about cost, because Jack Newton at Clio and the legal trends report that they put out has done a really good job at outlining what the problem is. And the problem is a multi-trillion-dollar product market fit problem between those potential clients for legal services and the actual providers of those legal services.
Right.
So that's not me. That's, well-researched. The industry understands that. So we have in my opinion, we have a huge opportunity to fill that multi-trillion-dollar product market fit problem if we can figure out how to provide that access to justice.
Right. And something that made me think of the way that you described it is that it's that blue ocean market strategy too, is you're targeting this massive market and you're not just trying to compete. Because I get this a lot, having the podcast, attorneys will ask me, or even not, other professionals in other industries, well, aren't you afraid of talking about and promoting the subscription model because you're increasing competition? But just like you said, it's a multi, I haven't heard multi-trillion, although I believe it. I've been saying around $1 trillion, but huge market opportunity. I could never serve all those latent legal market needs, right? Not as a solo. And how big is your firm?
Yeah, so we're 10 staff, 3 attorneys, and we are busy. We completely agree with you that there is far more work out there in that blue ocean, which, by the way, that's a very good book to plug, that blue ocean strategy book. Highly recommend that. But there's a blue ocean of potential legal clients wanting legal services. The way I usually phrase this is everybody wants an attorney. Not everybody can afford an attorney.
And people don't even know that they want an attorney yet, in large part because of the, obfuscated pricing and how, especially in litigation, there's the common understanding with anyone who's ever been through it that in litigation, the only people who win are the lawyers, even if there's an outcome, right? And so part of that is, I think, why people maybe don't think they want lawyers, but those who are able to afford them and see the value of not having to worry about the legal stuff anymore, now they definitely want them, which is really where this, even if there's an end game in mind, this recurring business model and ongoing relationship, comes back into play.
Yeah, I really feel like that attitude is a result of the hourly billing model that, the law firms have been using, and especially litigators. have been using for, decades, as long as they've been doing that. So the old model of retainers, doesn't work anymore either. But the hourly model creates a disincentive. So the flat monthly billing or subscription model, which there's a slight difference there. And I do want to be careful to explain what I mean by flat monthly billing, because the subscription doesn't, it does end. It doesn't, go on in eternity, which a subscription probably could. So if you had some of the subscription model firms, they're living with that subscription and that client in perpetuity. But we don't do that. The flat monthly billing ends at the end of the litigation.
Right. Right. Yeah. I mean, it's still so, the subscription economy in the legal industry is still so new that I feel like there is no concrete definition yet, even. And depending on the type of litigation, I see at least on your website, you look at just civil litigation, business, contract, employment, insurance, and you have real estate, commercial real estate, landlord tenant related matters. But I've got to imagine, in particular in the landlord tenant space, I have some landlords subscribe to me to just handle all their disputes with their tenants without having to take it to litigation. So that's more litigation avoidance than it is litigation, but there's an ongoing subscription. Are you doing anything like that?
Absolutely. Yeah. So one of our main three areas is landlord representation. California is very tenant friendly. And so the landlords there need wise counsel and certainly need unlawful detainers done for them so they can regain possession of their premises. So we do that work, and we do that on a flat monthly basis because it takes time. The genesis of this for us as a civil litigation firm really started when we looked at a basic lean study. Have you ever heard of the Toyota way or lean manufacturing?
Yeah, it's adjacent to agile and Scrum methodologies and such. Yes.
Exactly.
Yeah,
And
but we've barely scratched the surface. So feel free to go into that a little bit. Maybe
sure,
you want to explain what lean means.
sure. So Toyota was the genesis of that. And there were some, leaders in that movement, which goes very deep. There's some great practitioners in lean, but the gist of it for us was, what of our process could we make more efficient? And that's what Toyota does. That's what they're famous for, trying to make the manufacturing process just a little bit more efficient than it was yesterday, right?
Right.
So we did a very basic lean study on our legal process for litigation, and we quickly understood that we do our jobs quite quickly in comparison to everybody else that we have to deal with. So, for example, there are long delays in any civil litigation matter based on waiting for information from the client first, waiting for information or correspondence from opposing counsel, the process server, the court, sometimes the opposing party. There are mediators, deposition companies. All of those things take time. And those things are not things that we control. That's the part of the process, but it's not internal to our office. And so only those pieces of the litigation that we are in control of can we make more efficient. Does that make sense?
Yeah, I mean, I'm right there with you. I concur with everything so far. Keep going.
And so the hourly model says I'm going to work so many hours, and yet I'm not in control of the process itself. There's many vendors and other people, the court itself, that the process has to go through in order to actually achieve justice or get the lawsuit done, get it settled, get it resolved in our favor with a judgment, get that judgment enforced. All of those things have to happen. And lots of it, in fact, the majority of it, we are not in control of, which means that lean and agile and those sorts of things are good. All of those are efficiencies for the system of litigation. However, they pale in comparison to understanding that there is a difference between motivating yourself on an hourly basis to just push all of those other vendors and your employees for that matter to try and push the ball forward, and understanding that some of those things take time, which means what we did is we looked at that and said, okay, we're not in control. I'm not in control of all those things. So why am I trying to push all of those things Instead, why don't I bill on a flat monthly basis? And those things that take time, and I don't have to stress about them. The client doesn't have to stress about them, or more precisely, pay more of my time for them.
Right.
And we can get it done when it gets done, and we can push the ball, but we're not in control of any of those things. So we make sure that we do our job efficiently. Absolutely. Want to do that? We're good at that. It was obvious immediately that we do our job fairly quickly. We turn things around in our office in about 24 to 72 hours. They're done. Fantastic. What we wait on is everybody else, right? And so a good office, that's the case. Well, what the frustration becomes is I have to push the mediator, opposing party, opposing counsel, the court, in some cases, the clerk's office, you name it, in order to try and get things done. And rather than do that and run up the bill, unfortunately, that's what happens just by the nature of that more time gets put into it. Then it's better to bill in a different way, knowing that the system is inefficient in and of itself. And I'm all for fixing the system. That would be great, but I don't have that power. I only have the power to change my office and what we do, right?
So it sounds though like you were billing time and like you were looking for a better way. Am I right?
Absolutely. Yeah, we moved to flat monthly billing over 5 years ago. So we've been doing essentially subscription or flat monthly billing since first of the year 2019. And before that, we were an hourly shop.
That's interesting. Good timing, because then when all the courts shut down, you were still making money, right? I mean, or how did you handle that? Because a lot of things got super delayed and it was really outside of your control, where you're still getting those monthly fees, even when courts were in limbo.
Absolutely. Yeah. What we did is we were very pleased with the court's adoption of some of the technologies that have been around for a while, like Court Call, Zoom. Those things happened during COVID, and some of the courts that had been reticent to adopt those technologies adopted them. And so we got things done that way. We did our first depositions over Zoom that we'd never done before, even though the technology had been there. So we adopted more technology as well. COVID was a very good impetus to adopt new technologies. And so we did that, and the courts did that. Everybody was doing that at that time. And some of the benefits of that have shown us that that's actually more efficient to do it that way than to drive to the deposition or the mediation if possible. It's not exactly this. Go ahead.
Pay for the expert to fly out, and all those expenses associated with that. But that's massively important, though, that you had already switched before the pandemic, because in 2018, I went to the firm I was with and I said, hey, I've been doing this research on the subscription thing. I think maybe we should try something like that. And they thought it was a good idea, but they didn't really put any effort behind it. And then the pandemic happened, and more than half of our billable hours that used to be in court dried up. They went away. And when they came back, it was 15-minute Zoom hearings, and we didn't have to go to court and bill for all that time and sitting around waiting for your case to be called. You just sign in when your case is scheduled. And so it never came back. And then they were like, oh, well, what about that subscription thing that you talked about a few years ago? Now they were interested even more. And they, to be fair, they did support me in developing that out. We just couldn't make it work at a billable hour firm, which brings me to my next question for you, Jody, which is, how did you actually make the switch? Because people think, oh, we'll start doing one subscription and we'll still do billable time. And then they end up not doing subscription, right? Because they never actually make the full pivot. So was it a cold turkey type thing, or did you have this ease in period?
No, there was an ease in period, although I don't recommend that. I think cold turkey would have been better. I eased in to flat monthly billing starting in first of the year 2019, because we already had agreements in place with hourly billing, prior to that. So we just honored the agreements that we had. And rather than try and switch those with the current clients, new clients were put onto the flat monthly billing system, and that aggregates over time. So I think that, the model is viable. We are able to do it profitably. We know what we call SKUs. We know our SKUs. We know that we are doing this profitably at industry standard profitability levels. This works. And I would encourage listeners to pursue this.
Yeah.
You
So
know,
you say SKUs. I'm looking at your website right now. Pricing tab. Welcome. I think now there might be more than 50 of us out there who actually list pricing on our websites.
yeah.
So I'd say welcome to the club, but I'm assuming you've been in it for a while. But nice to know and nice to meet a fellow club member, I should say. You've got your 6 tiers listed, and they very clearly state in each one of these what's included in those what I would normally call a subscriber benefit. And I know you're not adopting the subscription, terminology. I still think you could have subscriptions that end. I mean, you have, short-term subscriptions. It's a thing. So like these subscriber benefits or member benefits or whatever you want to call them, flat monthly billing benefits, just doesn't roll off the tongue as well, Jody, as subscriber benefits.
You're right. You're right. Subscribe, it does. It's nice. And we're even pursuing and talking about internally some, longer term subscriptions. So it's not that I disagree with you. I actually do agree with you because when you do flat monthly billing or subscription, it's billing as legal as a service, much
Right.
like software as a service bills on a flat monthly basis for their work. And that has been a very successful business model for that industry, right? So if we learn from some other industries where that has been the case, others, software is not the only one, but when you put legal as a service into this model and do it on a flat monthly basis, it aligns the interests of the client with the interests of the firm. And that is the efficiencies now mean that we are able to do the case, for example, quicker or in less time. Well, as an attorney and as a business, it's my responsibility to make sure that we can provide our representation and our counsel in a profitable manner to our clients, right?
Yeah.
And so I have to make sure that we make profit.
Yeah.
How do we do that? Well, if I can be efficient underneath the price of the services that I am providing, that's how I make profit, right? I have to have cost of goods sold, including all of my labor, has to be less than the amount that I'm providing or I'm charging to the client. And so very basic, obviously, but if you have an efficiency on an hourly basis model, it doesn't help the firm make more money. That's why the industry is scared about new technologies like AI, because, well, if I don't have to spend the amount of time on the litigation that I used to, I may not make as much money. Or, for example, in COVID, we saw the courts shut down. Well, what do I do if I don't have to be in court? Well, obviously, lawyers are smart. We will figure out how to serve the clients. And my recommendation is to switch the billing model to flat monthly billing or subscription, as you call it, in order to make efficiencies a benefit to the attorney, right? Because what we can then do is provide justice or access to justice to more people than we could on the hourly billing model, right? And so I want to be really clear about how we do this because it's really important. The only way that you actually provide access to justice is, first understanding the terms, right? Access means equal opportunity, not equal outcome. Justice means access to that which is right or just. And here, what we're talking about is access to the courts. We understand that that's already there. Pro per litigants can already access the courts. The problem is the court system itself is difficult to navigate, and therefore professional counsel are highly advisable, right? So he who represents himself has a fool for a client. So what we're really talking about with access to justice is an equal opportunity to attorneys, right? So let's identify the problem. The problem is we don't have access to wise counsel and representation in civil litigation matters. Why do I say civil litigation? Well, because it's a civil problem. It's not a criminal problem. Access to justice already occurs in criminal defense cases. They have their public defender, right? And those guys do a good job. Don't tell me they don't. I believe that they do. I've seen those guys. I met those guys. They represent their clients well. That's not an issue for justice. We have public defenders for criminal cases. what access to justice really is an issue of civil law, right? We don't have access to attorneys for most individuals and small business for them to understand what their legal risks are and for them to have representation in civil court. So all that to say, the reason why that's important is because if you can set the flat monthly billing in a tiered fashion, if you can tier it, meaning there's an entry tier, a lower tier, and the tiers step up based on the amount in controversy, which is how we do it. If you can tier your offering based on the amount in controversy, you can offer a lower tier for smaller cases. Why is that important? Well, that's the access to justice issue. The smaller cases are the ones that go unrepresented, where the client has to do it themselves. The civil litigators are not able to handle smaller cases because why? They're worried about inefficiency. Inefficiency is a very big problem in civil litigation, right? If we are worried about the total attorney's fees costing more than the amount in controversy, most civil litigators won't touch the matter. Well, the way to solve that problem and to actually increase your clientele is to have a flat monthly tier for smaller matters. Well, how do you do that and how do you do it profitably? Well, you have to tier your flat monthly offering so that the higher the amount in controversy, the higher the flat monthly bill, right?
And I do want to point out, because I'm looking at your fee page right now, that you also have tiers for pre-suit. And I think that that's another really important thing that I just want to point out as you're talking about the amount in controversy being one of these distinguishing factors for the tiers, which is really great information for the listeners to hear. Because I also want to point out that it's not just efficiency is not just the win for the attorney, which you said outright, but you've certainly been implying, and I want to say it outright, it's a win for the client. But I also think I think it's a win for the courts too, because if you have these pre-litigation tiers where you're resolving matters for clients before they even end up in court, then the courts win, which also means the taxpayers win. So it's actually a four-way winning situation when you abandon the billable hour and start adopting efficiencies.
Absolutely. I completely agree with that. So to explain the tiers, we have a base tier at $1,900 a month with a $6,500 deposit. Could it be lower? Yes, I'm working on that, but I'm not there yet. So it does take a $6,500 deposit and $1,900 a month in order for us to be able to work together on a civil matter. However, at that monthly, we can represent cases in what in California is called civil limited cases. Civil limited has been one of those areas, like we just talked about, where most attorneys don't touch them because the amount in controversy is in California now, it's 35,000 or less. Amount in controversy is put on a different docket, a different calendar. It's a sped up docket. They're in our counties that we typically work in are about 8 months to trial. Trials are stacked. And so civil limited cases are smaller amount in controversy. Obviously, there's also small claims, but we can't help in small claims. We can help prepare for small claims, but I can't actually represent anybody in small claims. That's a third system, right? So there's civil limited is 0 to 35,000 in California. And at $1,900 a month, we can represent people in civil limited cases. Why? Well, because not every case is going to take all the way to trial. In civil cases, 99% of cases are going to resolve at some point before trial. And even in a civil limited case, most of those are going to resolve before trial. So if trial's at 8 months, you've got, 6, 7, 8 months typically before it's going to, go to trial, and it's going to resolve at some point in there, right? So you're looking at a few months worth of work on that case in order to get it done and resolved, because the entire system, the court system, is set up to resolve cases before trial. There's not enough physical courtrooms to handle all of the cases that the civil courts have. Therefore, it's a waterfall system. The longer you go, the more water is hitting your head trying to resolve your case before you actually get to trial. Now, granted, if a case needs to be tried, try it. That's great. But the system's set up in order to resolve cases beforehand, right?
Yeah.
So they encourage mediation. They encourage, early mutual dispute resolution, all of those things.
Time is flying, Jody, and I have so many questions I want to ask you about like more of a focus on the model even than the system itself, because the access to justice conversation is an important conversation to have, and we could chat about that more. But let's go back to the model. So like your clients, because people want to know, because they're like, oh well, yeah, sure, it works for you because you're in Texas or California or whatever, all these things you're saying, but it's not going to work for me because my clients aren't going to want to do it. So that's why I want to ask you about the clients. So like. So the clients that are hiring you, are you finding that, and I'm going to ask you a little bit of a compound question, answer it however you like. Are the clients that you're finding, are they institutional clients who have paid billable hours before? Are they new clients who were previously priced out of legal services? Some combination in between? And then what are they thinking? Do they like it? Like what feedback are you getting?
Oh, they're very happy. Most of our clients are individuals and small business that would have gone unrepresented. Civil limited cases represent about 40% of our total caseload. And we would have otherwise refused those cases because of the fear of inefficiency before we started flat monthly billing. So we increased our caseload by about 40% just by doing that.
And then are you finding that there are people who maybe they've hired a lawyer before and they hated the billable hour, which made it an easier sell? Or are you having this, is there like an education gap with trying to explain what flat monthly billing means to them?
Rarely. So most of the clients understand flat monthly billing once we explain it to them. It's not as you can tell, it's not a difficult concept. They're used to paying flat monthly fees for all of their other services, their mortgage, their cable bill, everything else, their rent, if they're a tenant, all of those things are done on a flat monthly basis. Most services are provided on that basis. So they get it. That's not a hard education for them to have. We don't have to educate them is probably a better way to say that. So and your second part of that question is, are they happy? Absolutely. I have far, far less conversations with clients about the bill because we've moved to flat monthly billing. When I was at hourly billing, we have a lot of conversations about the bill, typically because the client will ask me these things. Why did this take so long? And I am not necessarily in control of why things take so long because, as we talked about before, I'm waiting for the process server, the sheriff, the court, the opposing party, opposing counsel, all of those things I wait for. So I'm not in charge of those things. I can't control that process. So with flat monthly billing, I'm not in control of those things, but the client understands at the end of every month, it's going to be $1,900 or $2,500 if we're out of court on a slightly bigger case, or $4,000 on an unlimited case up to $85,000 and $5,500 a month on an $85,000 plus amount in controversy. Those are our basic tiers, which are on our website if you have interest.
And prices change all the time. And since these podcast episodes do get published, sometime between the actual recording and such, but that is a question I want to ask you is like your pricing, you've been doing it for 5 years. Has it always stayed the same? Have you increased? Have you decreased? Like where have you made changes in your pricing and your pricing structure? Like this is also a chance for you to answer the question of like, what are some mistakes you made early on that you realized, oh shoot, we got to like fix our pricing or fix our other stuff about this model?
Yeah. The lessons that we've learned with flat monthly billing are, one, that it works. Two, that it increases our total caseload. We can help clients with smaller matters. So we've increased the total caseload by 40%. And we've done so profitably because we dove into our SKUs. We understand what our cost of goods sold is, meaning essentially with law, you're talking about your labor. That's your biggest cost of goods and everything else on top of that, right? But we dove into that to make sure that we were profitable. And in the beginning, we took a flyer. We estimated what we would need to be at in order to be profitable on a monthly basis. And we did some very basic arithmetic, right? We set what our revenue what we wanted our revenue to be. And then we divided it by the amount of cases that we already had in-house, and you will get to an average monthly fee. Most attorneys, if they will do that simple calculation, what revenue do you want? and divide it by the total number of matters in-house, and that will give you an average flat monthly fee that would get you to that revenue. That's a very simple calculation, right?
Right.
We did that and we said, okay, well, we need to average, call it 2,000, 2,500 a month on each matter. So we need some larger matters, we need some smaller matters. And if we're going to have a lot of smaller matters, then we need to make sure that we're still profitable overall. And really, the clients have been very happy with that, because the clients understand at the end of every month, it's going to be the flat monthly fee plus the expenses. Obviously, I'm not in control of the expenses. We add the expenses on. So within the range of the expenses, but the expenses are small compared to the flat monthly fee. And so, yes, could that increase their bill? Sure. But it's going to be at least our flat monthly fee every month. And they know that if they're not able to handle that over time, we are able to make business decisions on the litigation, which you end up doing anyway with hourly billing, but you have less information.
Mm-hmm.
So the flat monthly billing allows you to say, okay, this is how much attorney's fees it's going to take to get to trial, right? This is how much we're going to spend in attorney's fees. If you don't have that, you're reliant on their estimations. Well, we think it's going to take 10,000 or 15 or 25,000 in order to take this case to trial, or just to get up to trial. And then trials like, 6 figures, whatever, that allows us to provide business decisions that the clients can make based on how long it's going to take to get there. And we know that because the trial's set, right?
Right.
So that has been very, very good for flat monthly billing as well, because that also was a blind estimation that we would have to do in days prior.
Right. It's going back to this whole profitability thing and the time savings and efficiency wins and all that. And I'm trying to parse it together for just in case this is somebody's first episode of the podcast they're listening to. And so, correct me if I'm wrong and anywhere in here, but I'm curious to know, because there's a question at the end of this, but it sounds to me like with your increase in efficiencies, you're able to continue to do the work that you were already doing before you switched from hourly to recurring flat fee. And then what that freed you up to do was to bring in a heck of a lot more cases, because the subscription model, the flat fee, is all about scale, which it sounds like you've done, which makes you more profitable than you were before, spending less time on average per matter or controversy, which is the inverse relationship in top of the billable hour of time and money. I want to spend less time and then I make more money. And it also could free you up, and I'm curious to know, to spend more time with your family or do more things with your friends. And are you taking advantage of any of those wins too? Or is it mostly just no, we're going to bring in a heck of a lot more clients now?
Those efficiencies tend to, go out the window pretty quick, because you will fill the time with additional matters, right? And the calculus for flat monthly billing becomes your churn rate. So software as a service has what's called a churn rate, which is if you achieve what's called net negative churn in software, that means that you are positively aggregating your total number of clients month over month, right? So net negative churn is a good thing. We want net negative churn. And what we've been able to show is that by doing flat monthly billing and opening ourselves up to those civil limited matters, we were able to achieve net negative churn, so that we are aggregating positively each month that we continue, so that we have more matters in-house this month than we did last month, and we will have more matters in-house next month than we did this month. Make sense?
Yes.
So that means that because you have more matters, you're also growing revenue. And the game becomes one of not working harder to make more money, which the hourly billing certainly requires. And specifically, it also requires you to force your employees to do that. Instead of asking your employees to find more efficiencies, you're asking your employees to just work harder. I don't think that's really a sustainable model. So in answer to your question, yes, it has some serious benefits for the firm internally and for the clients. The firm internally is there's less stress put onto the employees and the attorneys to just bill, and bill more hours, instead of, no, do what needs to get done regardless of how long it takes, because we want to provide good representation and wise counsel on that litigation matter. And the litigation matters, because we are billing on a flat monthly basis, we can spread that risk out of any one matter taking a lot of time across the firm, right? So you have outliers where there's a ton of time spent on that matter in this month, but that's not necessarily going to be the case on that matter next month.
And
Makes sense? So
you win more than you lose, meaning that on most matters, you're spending way less time than you maybe would have if you were billing by the hour. And that's the important thing.
yeah, I mean, I think that the flat monthly billing, you have to, depending on where the price is set and where your cost of goods sold are, you have to understand what your cost of goods sold are. If you don't understand your SKU, if you don't understand what it costs to actually produce all of these hours, then you can't look at it and say, well, this is how to make profit based on a flat monthly basis. You can do what we did and take a guess, and then you'll figure it out. But we did that, and then we dove into our SKUs, and we were right. Our guess was correct. What I would recommend is getting a hold of your SKUs first, and then basing your flat monthly fee. But we're certainly, not holding back our pricing. It's right on our website. This is what it costs. And that also is very helpful for the intake process, because the clients understand where the pricing is going to be.
I know I had a pricing expert, Mark Stiving, on the podcast, and ever since then I've been consuming a lot of his content. And one of the things we talked about in that episode that he always talks about is clients don't buy, problem solving. They buy the solution, and they buy the value of the thing. They don't buy the price or whatever. But in an industry that has been long dominated by opaque pricing, having a known price is valuable to clients. So that's also a valuable thing. There was another thing I wanted to make sure that we covered. Oh, yes. It was something very wise that you said that I think needs to be highlighted again for listeners. And that is because this is where I also get, when I'm presenting on this live, people say, what about that one case that takes you way more time? Because that's where lawyers like to focus on those problems, because we're trained issue spotters, right? We're like, there's the problem, that's the problem. But what you said was it spreads out the risk. Having that monthly recurring revenue amongst all of these cases that you're working on. And so just wanted to highlight that's a really important takeaway. That's like, a clippable thing. If I was better at social media, I would clip that and throw it up on social media, right? Because that's huge that you have that mindset, because it requires a mindset shift from lawyers. It really does. So I just wanted to highlight that. Now, you did mention, time is flying, you did mention that you something about AI earlier. So I do want to know, like, what technology are you using to support your efficiencies for your practice? And is AI part of that? And if so, how?
Yes. So our tech stack is basically Clio Grow, Adobe, all of the normal sort of cloud-based legal softwares that are out there. We use AI. We are starting to use AI for drafting letters, some of the more basic things. Mm-hmm. It's really in its infancy, and you want to make sure that you're using AI for things that are not that the AI is designed for. So the Ed Walters from Fastcase, or, formerly from Fastcase, said this well at the ClioCon that I attended. He said, ChatGPT is not for citing cases because it's not designed to cite cases. Yes. There are AIs out there that are designed for that purpose. And it's my understanding that he and his team are working on those things, but ChatGPT is not one of them. And so we get ChatGPT has been, essentially equivalent to AI. Well, that's not actually the case. There's lots and lots of different AI models, ChatGPT being one of them. ChatGPT is really good for organization, and we're using it for, a little bit of analysis and organization, bullet pointing, that sort of thing. But we're still in our infancy as far as that is concerned. But we have the correct billable model in order to benefit from that. Whereas the industry is going to go through a shift where they understand what you and I are talking about, which is the hourly doesn't lend itself to gaining efficiency. The hourly model says, if I spend more time, I make more money. That's a bad idea. So it would be better to have efficiency mean that the attorney, the firm, makes more money. Well, if we're going to be more efficient, then we can be more profitable doing that, which means we're happy to adopt AI. we're trying to adopt AI. We're not fighting against AI.
Right, right. Now, and then the answer might also be Clio, but to power your subscription, like pricing and automations, if you've got that automated, like what is powering that? Or are you get the retainer and you draw against it and you ask for checks? Like, how do you handle that?
Yeah. So we use what's called an evergreen retainer system, or deposit system is probably a better use of that term. Retainer is old school. I will pay you X to do whatever I send to you during this time period, right? That's a retainer. A deposit is funds that are put into our trust account ahead of time in order to bill against when the bill comes due. So we use a 3-month deposit. So we estimate the deposit at 3 months of the monthly fee, plus a little bit of money for the expenses. And that's the deposit that we ask for ahead of time. So we talked earlier about the lowest tier being a $6,500 deposit, even though the flat monthly fee is $1,900. That means that when we get engaged with someone as a client, we know that we're going to be able to work with them at least for the next 90 days, 3 months, without them even refilling that deposit at all. It also helps us understand if the relationship needs to break down and we need to withdraw or file a substitution of attorney. Then we understand when we need to do that, because we're billing against essentially 3 months in the trust account. So it helps us make better decisions about when to disengage from clients that are not paying. We can do that ahead of time before we are losing money and spending time that we're not going to get paid for. So it really helps on the AR. Our collection rate last year was 96.4%.
Yeah, I mean, in the transactional side of things, I mean, and in Illinois, I could get, like, my collection rate is 100% because I can just charge for everything up front if it's a fixed fee, and subscriptions recurring fixed fee. And so it goes right into my operating account. But for litigation, that is an astonishing collection rate, just astonishing. Okay. And so, but then, like, the procedures of it, do they put in their ACH information? Do they send you paper checks? Are any paying by credit card? Like, because this is,
Yeah,
people care about the price, like how you do pricing on the Law Subscribe podcast.
sure. So what we do is credit cards mostly. So we use Clio payments for that. They give us, or they input into Clio payments. We don't actually see the credit card information. They input into Clio payments their credit card information. And then 30 days after they engage us, their first invoice is given to them, and we deduct from the deposit that they entered the first invoice plus any expenses, which is also included on the invoice, of course. And then they are sent a trust reimbursement request to reimburse the trust with the amount of the first invoice, so that there's always that 3-month deposit with us in the trust account.
Okay, great. Then for like any automations for like forms, like any technology you're using specific for that, obviously longtime listeners know Gavel, which automates, legal documents and other documents and stuff, longtime sponsor of the show. But there's a lot of software out there that does that, or even just Microsoft Word has templates that you could use, although I know a lot of lawyers don't actually leverage that. So, like, are you using templates or automations, things to create more efficiencies in that way?
Yes, my production team is fantastic at that. What they generally do is create their own internal templates and typically save them in Clio. We're using a couple softwares that I can't remember the names of right now for some of those, but
yeah.
Yes, if it's an efficiency gainer and its price is not too high, then we will use it because the model allows us to do that. We have spent a lot of time trying to figure out, how to continue to grow the top line, or the funnel on the intake side, over the last couple of years, as opposed to just the efficiency. Given what we talked about with the lean study, the efficiency gains are great, but more clients is more important.
Right. Right. Well, if you're considering the cost of your subscriptions, you could save 10% on Gavel if you use the code Law Subscribed. So there you go. There you come
Yeah.
to the show. You'll get a discount if you want to try them out. I think they're free for like a week or something to give them.
Yeah, that's
around.
Orna, right?
Yeah.
Yeah, she and her team are fantastic. Met them at the Clio conference. They're doing some great things. We will be using those efficiencies. Like I said, the model helps us with those, and Gavel's certainly at the top of that list.
So I will tell you too, because it's very new. Her and I just did a LinkedIn Live about it, but in terms of publication of episodes, you wouldn't have maybe heard that yet. Is they launched this new thing called Blueprint, and you put in, and especially if you already have templates, it's going to be even easier for your firm. For me, I'm just using actual documents, and you upload it, and they use Gen AI to figure out where all the templatized things are, and they build that automation for you. So where it used to be you had to go in and build out your own logic, or your team members did, or a freelancer you hire. Now AI does, like, it gets you like 80-90% of the way there. So it saves, talk about a time savings for building that automation. And I haven't seen some of these automation tools do that yet. And it's in beta, so it's not perfect, but it, like, one of my biggest hangups from using my own sponsor even more was, like, it took so much time to set up these automations, and the net time savings is ridiculously worth it, but it's still like that initial time investment to set up these automations. Well, with Gavel Blueprint, now you could just, like, it gets you like almost all the way there. Now I have some automations I've been wanting to do forever because of that. So it's just something to think about. And I know I'm like hawking like my sponsor, but it's like, they're a sponsor for a reason. They're like legitimately like really help law firms that care about efficiencies like you've been talking about, which is why I brought them up.
Yeah, absolutely. I think that the things that we've seen from Gavel in the past are fantastic, and that sounds like a really good use of their time and our time to check that out. So thank you.
Yeah, definitely check it out, or have your people do that. So, we talked a little about, so just wrapping up the show here, trying to tie it up in a neat bow, though I feel like I got to have you back on in a few months to, like, fill in all the gaps of the things we skipped over. 5 years ago, you discovered lean, you decided billing time wasn't the way anymore, and your firm set out to do the thing that you're doing now, and you've had some lessons along the way. What I want to know is, like, what is it about you and the other leaders at the firm that made you want to do this? Because, like, there's so few lawyers actually do it, right? And is it just the entrepreneur's brain? I've had some people who are like, well, I'm ADHD and I was never going to be good at tracking time. And frankly, it's been a lot of women and attorneys of color that, like, the institutional legal industry didn't work for them. And so they went out to go do it a different way, and what they thought was a better way. So what is it, do you think, about you and and the other, firm leaders?
Yeah, it fills our mission. Our mission is to provide access to justice, man's justice, and God's justice. And we talked a little bit about, when in fact we talked all about man's justice on this program. We could talk about God's justice some other time, but he works on a completely different scale, right? Like we get mercy when we deserve punishment, right? So that has been really important to me, and I was really tired of not being able to help viable clients with actual meritorious matters that just had a smaller amount in controversy than I could guarantee was efficient. So we tried to develop a system. And by the way, when we started this in 2019, I didn't know anybody that was doing subscriptions. I didn't know anybody that was doing flat monthly billing. We did this on our own. We quickly learned that we were not alone and that this movement has merit. But when we started, we didn't know anybody. So it's great to meet you. It's great to meet the community. I highly recommend it because we were tired of having that conversation with a meritorious, viable client that I can't represent you because your amount of controversy is too small. Well, that's ridiculous. Let's figure out a system how we can represent them instead of just saying no.
I mean, it's really interesting, and I love the perspective of, if you actually stop and think about it, if you are a person of faith, does your faith comport with the billable hour and the effect that that's having on society? And that's a first of its kind, sort of a part of the reason why you pursued a different way. But I find it absolutely fascinating, and it makes me think that we should have a heck of a lot more lawyers abandoning the billable hour in light of it, right?
Yeah, I think that the call to do justice for people of faith is a very strong one. It's a biblical one, and so I take it personally and that's one of the reasons I went to law school. I take it personally when I'm not able to provide that justice to otherwise, valid clients, and
Right.
simply because their matter's small. I can't help them and remain profitable if we don't get paid, but
Right.
at least I can figure out a way for us to be able to provide that access to justice for that huge segment of the potential legal market that's not currently served, right?
Right.
And all the other benefits that we also talked about. But really the genesis of it was we were very tired of not providing that justice to the people that we went to law school to try and serve.
Yeah. Yeah, well, I don't think we're going to get better than that. So, Jody, hard pivot here. I'm going to ask you the question I ask all my guests, which is a hot dog a sandwich and why?
Absolutely. Hot dog is a sandwich. It's got meat in between bread. That's a sandwich every day and all day.
All right. Well,
Why? Yeah, meat between bread. Like,
yeah,
you
it's
know,
a good.
I feel like the Earl of Sandwich that came up, that the sandwich is named after. They put meat in between bread. That's how we got sandwich. Period. So I'm going to go with yes.
All right. Answer accepted. Not that I know what the right answer is. People wanted to follow up with you. What's the best way for them to do that?
Absolutely. Well, our website is www.lloydwinterlaw.com. That's Lloyd with two L's, winter just like the season, LAW.com. All of our contact information is there, including our pricing. We're happy to talk about flat monthly billing and what it's done for us. Just give me a call and we'll set up a time.
All right. Thanks so much for coming on the show.
Excellent. Thank you.
And that's our show. Thanks again to 650 and Gavel for being sponsors. The best way for others to discover this show is for you to share it with somebody you think would find value from it. Follow me on LinkedIn, since that's where I'm most active on social media, and click the bell towards the top right of my profile to get notified about all of my posts about this podcast and everything else I think is valuable for you to see. To get in touch, message me on LinkedIn or email kurbis@lawsubscribed.com. All links are in the show notes. Until next time, this is Matthew Kurbis with Law Subscribed.